I want to welcome you today to an exposition on the category of record that I used predominantly early on and learned how to use very early in my career as a genealogist with the assistance of some older and wiser heads that used to accompany me on my research trips, my mentors, mostly elderly ladies in the local genealogical society. And this is what they taught me. And what I learned on my own over time as I interacted with the records, I learned that often the quickest way to establish relationships and connections within communities of the past was to go right to the category of records we know as probate records. And that includes things like last wills and testaments, first of all, and then also the loose estate records or the probate papers. These are all the records that are associated with the settlement of a person's affairs after they die. All of their debts, all of their obligations, all of the sums of money that were owed them, their legal contracts that were still open and unfulfilled, everything that they left without any final arrangement in had to be handled by someone appointed by the court or appointed by the individual themselves if they had enough forethought to settle their affairs. And it reflects a nexus of connections that that person had in their lifetime, including kinship connections, but not limited exclusively to kinship connections, especially in the latter part of their lifetime. So it can be extremely revealing and not necessarily just about the kin group of the deceased person, but about the wider community. So they were a treasure trove to me, and thankfully in North Carolina they are arranged in a very logical manner by the deceased person's name and the date. So it's quite easy when you go to the state archives to access them. And now you don't even have to do that. They've all been digitized. They're all available. The portrait, or rather the painting that you see on this title slide is Sir David Wilkie, a Scottish painter's representation of the reading of a will, which he did at the commission of the King of Bavaria in the 19th century. It's a genre painting, but it's supposed to be a bit of send-up, sort of a satire on how people who are interested in the estate gather at the decease of the person, and you can see that they've been rummaging through the trunk on the floor to find the deceased's will, his last wishes and final dispositions. The lawyer is reading aloud, and everybody is reacting in the room. Some of these people are revealing their true selves, and the deceased portrait is on the wall. And of course, we find out a lot about people when it comes to estate settlements and wills. That can be a very revealing process about individuals and their character. And this is no different in the past than it is today. And we too can learn a lot about our ancestors and their kin group from what comes up in these records. So we have a chance by studying the documents associated with the sifting out at the end of life, which we call the probate process, not only to learn more about the deceased and his business affairs during his lifetime, but also to find clues as to his relationships, his land holdings, his attitudes, the prior relationships and patterns of inheritance in the family, and the names, ages, fates, and characteristics of enslaved people when we're talking about southern estates. Sometimes even relationships among the enslaved and clues to their major life events can also be revealed. In this lecture, I will talk about two major ways property tends to be sorted at the death of an owner, where these records can be accessed, and how they're typically structured, and also how they reflect the legal process of probate. And then I'll analyze each type of record for the details that it can contain and how those might benefit your family history. Last wills and testaments simply are the explicit wishes of a person rendered prior to his or her death, either orally or in writing. In early modern England, the will and the testament were two separate documents. The will covering the landed estate and the testament covering the personal estate. But later, when laws restricting inheritance of land eased, the two legal forms were combined into one, and thus we call them a last will and testament. Nevertheless, remember that land and movable property remain important, separate categories in estate law, and they're treated quite differently. Wills usually follow a very restrictive outline, beginning or ending usually with the date on which they were drafted, starting with some statement of faith, which may indicate something about the deceased's religious leanings or not, an affirmation of competency, because you have to be competent to make a will that's valid, and then detailing item by item instructions on how property should be sold, administered, or divided, and upon what terms. In fact, wills are often broken down into clauses or provisions, each a different bequest or directive that begins with the word item. So the first item and the second item, and so on. The first item often starts out with the words "in the first place" or "imprimis," which means the same thing in Latin. And that clause often deals with how money is to be raised to pay debts and burial expenses. Debts the deceased had incurred had to be paid, and debts owed to the deceased had to be collected before any distribution of assets to the heirs could occur. Now, the will may designate a guardian for minor heirs. Trustees may be put in place for particular heirs, whether due to their age, their tender years, as it's often said, or their incapacity, their illness or disability, their youth or recklessness, or perceived bad marriage for a daughter, like to protect the daughter and grandchildren from the financial irresponsibility of a husband or father. Wills may also make provision for the testator's own burial or the commemoration of loved ones long deceased. Their provisions sometimes also include charities. Now remember that in most of the period that we're speaking about, testators had wide latitude to do whatever they pleased with their property, both real and personal. The only real restriction, they could not disinherit a wife or provide her with less than a third of the estate for life, which is called her dower right. Children were eminently disinheritable, although sometimes a testator will leave a petty sum to each individual child or indicate that sums have already been advanced to that child to preclude unnecessary conflict at law. In the colonial period, too, certain lands might have been entailed years ago by an ancestor, meaning that they had to pass down a particular line of inheritance that ancestor had designated, and it was usually the eldest direct male lineage. Now that arrangement precluded the testator from bequeathing them that category of property to anyone else without an act of the legislature. Finally, sometimes in the colonial period, elder sons will be completely omitted from the will, because it's assumed under the law of primogeniture that they are entitled to any landed property not mentioned in the will. If a Southern testator doesn't mention certain lands in his will during the colonial period, you can assume that that land went to the eldest son automatically. Of course, primogeniture and entail were abolished after the Revolution, almost immediately afterwards, so they don't hold after that. Now, these documents usually end with an appointment of an executor or executors. Can be more than one. And for feminine, a woman that's appointed as an executor, and that can happen, we call those individuals executrix rather than executor. So the gender of the officer appointed to settle the estate by the deceased is revealed in how the word is written. That person has to carry out the deceased's wishes, and it also includes at the end of the will usually a revocation of all former wills, because people often went through a number of versions of their will and they wanted to make sure which one was going to hold primacy. That one would be the last one that they signed. The will is then signed by the testator, and that's the person making the will. We call them a testator, and by at least two witnesses present at the time of signing. Now, the witnesses are very important. They're often neighbors or people who helped to draft the will. Sometimes they're kinfolk. They should not be people who stand to profit by the will's terms, but disinterested third parties. One of them will have to stand up in court to prove the will when the executor brings it to be registered, or probated, as we say sometimes. When the court accepts the will is valid, it has legal force. The executor then has authority to carry out the will's provisions, and the usual probate process proceeds in keeping with the court's directives. When the court accepts the will, it will be recorded. That is, it will be copied over into the clerk's record book or will book. The original is often also kept. Other copies are sometimes made for the use of the family or for a case at law. That's important because even in counties where records have been lost, there may still be copies of wills in higher court papers if a case concerning the estate was appealed from the lower court to a higher court. Copies may even be found among private family papers. The copy of the will registered in the will book has a probate statement attached to it, telling which witness proved it in court, that witness that we call the jurod, and the date this was done. Now you can always bet that the death of the testator occurred between the date of the will, when he signed it, or she signed it, and the date of probate, when it was registered in court. And when tombstones are rare, that is essential information. It could be a relatively short period of time. Now you should know that there are quite a number of wills that are not registered by the court, and we call them unrecorded wills. They usually survive as loose documents in their own series. They're never copied into books because they were rejected. They may have been set aside by the court for some legal reason. Perhaps the testator was not thought competent to make a will, or had acted under duress, force of someone else, an influence, or prejudicial influence of some kind. It may be that the will was considered a forgery, or that the testator did not have any legal ownership per se over the property that she had bequeathed. And that's particularly common with widows, which is why I use the female pronoun. Maybe a later will was discovered and was found to supersede an earlier will initially presented for probate. And so that first will presented had to be set aside and was not recorded. Maybe the legal rights of a co-owner of certain property had been ignored by the testator, but the relationships cited in those unrecorded wills can be just as accurate as those mentioned in recorded wills. So if they exist, you should look for them. They may have been omitted from the indexes of wills that you commonly use. Now, a particular kind of will, an uncupative will, was made orally on the deathbed. It required additional witnesses to attest to what the person had said in court, and it had to be set down in writing as well as those present could remember it. Almost without exception, non-cupative wills are more brief and pointed than written wills. Remember also that testators sometimes altered their wills without drafting a replacement will. They did this through additions called codicils, which either add to, clarify, or modify the terms of the original will. Sometimes you'll find a number of codicils added over multiple years or months as relationships change, property holdings change, or even as heirs die or their circumstances change. Here the date of death must be between the date of the latest codicil in the series and the date of probate. Now, wills, of course, may be written by free African Americans just as by anyone else. There were free African Americans and other people of color in the South before the Civil War, and some were propertied freedmen after emancipation in the late 19th century. One reason freedmen took out cohabitation papers in 1866 was to regularize their marriages and legitimate their children by that particular individual for inheritance purposes. Antebellum laws did not recognize slave marriages, and given the chaotic division of families under slavery and the inhuman reproductive schemes of some masters, former slaves may have had several different partners and children by each. A cohabitation certificate may be an indication of which children the former slave wished to legitimate. If he died without a will, only the legitimated children of the cohabitation declaration would inherit. But of course, if he wrote a will, and he could include any and all children that he wished by any past union. Nevertheless, wills are much rarer in African American communities in the late 19th century or at the turn of the 20th than they are among whites. When you consider the financial difficulties of formerly enslaved people, discriminatory laws, unequal justice, and issues of illiteracy, it comes as no surprise. However, I would counsel you never to assume what you will or will not find. You could be cheating yourself if you don't look at probate records for African Americans. The main benefit of early wills for African American research is the possibility that white owners will mention enslaved people and bequeath them to specific heirs or designate them for specific purposes. Some slave owners also provided freedom or support for particularly valued enslaved people. Many older slaves who are nearing the end of their working years can be mentioned as needing care. Property may be bequeathed to a certain heir on condition of maintaining older enslaved people. Occasionally, the relationships between enslaved mothers and children are mentioned in a will, particularly if those children are under 5 years of age at the time of the writing. There was often an effort to keep very young children from being divided from their mothers, and I've seen requests that particular enslaved people not be sold apart. But most owners seem rather insensible to the human suffering that a will inevitably will incur at their deaths, and they take no provisions to avoid it. In fact, executors are sometimes given carte blanche by the testator to sell away slaves they find particularly nettlesome and ungovernable. Daniel McCrae of Mangum in Richmond County, North Carolina, for example, gives a list of slaves in nearly every clause of his will. Each set is bequeathed to a different heir. A good thing about this will is that it was written about 1860 and so gives a snapshot of his slaveholding just prior to the Civil War. A lot of the people he mentions will appear by name in the census for the first time just 10 years later in the 1870. Also, the clauses give a few clues here and there about relationships among enslaved people. If a slave owner directs that a certain portion of his enslaved people should be sold away immediately to pay debts or legacies, then you can look for newspaper advertisements and accounts of such sales, which may have been returned to the court and recorded in estate ledgers and papers. You may often see runaway notices in newspapers after enslaved people have been divided in an estate or sold away. The death of a white enslaver is a clear signal to keep your eyes open for the consequences for the enslaved people, including runaway notices from both purchasers at sales and executors, administrators intending to sell them. These always identify enslaved people by name and provide age, physical descriptions, special skills, clothing. They often suggest where the escaped person might be heading because of recent separation. If you see an enslaved person being freed and provided with some form of property in a will, the chances are strong that those persons are relatives of the deceased. If a male, often his own children by an enslaved woman. The example you see here in this slide is a clause from Henry DeBerry's 1805 will in Northampton County. DeBerry places land in trust with a couple of neighbors for the use of mulatto slaves he intends to free. He names them as King, Anthony, and Darkus, and census records show that they later did become free. Since DeBerry had never married and mentions a number of supposed or illegitimate white children as well, it's natural to assume that King, Anthony, and Darkus were also his supposed children. And supposed I put in quotation marks because that's how they often refer to such people. But he would not acknowledge them explicitly as such as he did with the white children in his will because of the social stigma. Of course, now autosomal DNA and Y-DNA can help us verify the relationships we have good reason to suspect through snatches of evidence like this. When such manumissions and endowments of property are made, it's good policy to check estate and court papers to see if any litigation arose. Laws about manumission got stricter as the rhetoric over the legitimacy of slavery grew heated, and many heirs rose up in court to overthrow provisions which deprive them of any portion of their property, including enslaved property. Remember, there are two copies at least of every will. One was the original, signed by the testator, and often turned into the court. It's the most accurate version of the will. The copy made by the clerk in the pages of a will book is a secondary record, but it's a pretty good substitute, usually. It may contain certain discrepancies and errors, and one or both of these copies may have survived. And additional copies, as I've stated, may be filed in court papers due to admission as evidence in a lawsuit, or preserved within a family's papers or an attorney's papers. Access to wills online is rapidly improving. Ancestry offers several databases searchable by testators' names. North Carolina Wills and Probate Records is the best example. A similar collection for North Carolina is the Probate Records collection on Family Search, which is not searchable. It must be browsed, but it has been indexed for North Carolina. It's worth, by the testator's name, at the auspices of the North Carolina Genealogical Society. It's worth noting that not all years or counties are evenly covered in some probate records on Ancestry and Family Search. It's not even the case that all the wills or estate matters represented in these databases have been indexed. Sometimes when using these digitized resources, you'll find wills and other estate papers by browsing through the images for the correct time period and using the handwritten indexes in each book to find records. Similarly, wills and probate records databases exist for many other states on Ancestry. But you'll be surprised by how Family Search's probate collections often supplement those on Ancestry. When it comes to North Carolina, Mitchell's Index to North Carolina Wills is another source and covers up through 1900. It's available also on Ancestry in digital form. It's called North Carolina Wills Database there, and it's available only to individual subscribers. But we have physical copies in the Heritage Research Center, and every good library will have it. Mitchell's Index, that is. The index tells you the name of every testator prior to 1900, whether the original or the will book copy survived for a particular will, the date of the will, the number of the county, and if the book copy survives, what the book and page number is for the recorded will. Similar indexes exist for many other states, some of which we also have in the Heritage Research Center. For example, 2 statewide indexes to wills and estates have been created for Virginia from colonial days up through 1865, and likewise for West Virginia. There are times, of course, when you will still have to order, film, or make a visit to an archive to see a will, but there's usually a way to find out whether such a will exists before you do so, either online or by using a printed index. It's always a good idea, in my opinion, to make a complete survey of all the wills for the surname that you're interested in a given county, and to take notes on every single one of them, even if you're convinced that the person who wrote the will is not your relative. The same is true of any surviving estate papers, a subject which we will address very shortly. On the screen, I'm giving you an example of how I would abstract a will like the one of Samuel Pate. Now, why do I encourage comprehensive note-taking on probate matters? Well, in the first place, it may turn out that you're not correct about your non-relationship to the testate or intestate person. By taking a comprehensive approach to the records, you may come across some references to individuals you recognize in your family, maybe not as a legatee or an heir, but in some other way, as having a business or a legal relationship with the deceased. These are clues that there is indeed some connection between your ancestor and that family. Also, by understanding some details about families who are unrelated to your ancestor but have the same surname and live in the same county, you're helping yourself distinguish your own family from theirs, getting clues to where precisely in the county they lived and who they typically did business with. That's called working by process of elimination, and it can be a powerful research strategy. For people researching enslaved families, It cannot be overemphasized. You must research the relationships among the white owners and all their marriages and lines of descent, preferably back to the late 1700s within a given county, or to whatever other geographic locations the slaveholders' marriage alliances or lines of descent lead you. Ownership of enslaved people will often flow along those white family lines. Of course, you're generally advantaged when it comes to slaveholders because they will usually be relatively prosperous and easy to trace compared to other members of the community. They will have many wills and estate records, and sometimes private records as well. So you should trace and take notes on probate materials discovered for each family tied by marriage or blood to the most recent slave owner that you've identified. If you're not sure who the slave owner was, but are confident of his surname, you must research every pre-1865 will or estate of a person with that surname in the county, and also look at families into which the slaveholding family married. For some slaves will have been acquired that way, sometimes as a gift or a marriage portion, and sometimes as a bequest or legacy. Every time a slave owner dies, you must think of it as an opportunity to find details. That year suddenly becomes a census year for you because in some form or fashion, the slaveholding is likely to have been described in some way, and the individual enslaved people may be mentioned in various papers and reports associated with the estate. If you have a suspected slave owner in mind, it could even be helpful to look at some estate records in the white family just after slavery came to an end, say the late 1860s through the 1880s. There could be some lingering business relationship between a former slaveholder and a former enslaved person, which might take the form of a lease or a debt owed or property purchased at a sale, and that could be extremely revealing for going back further in that lineage. And now we proceed to estate papers, which largely have to do with people who did not write a will. Now, such persons are described as intestate. That's the word, intestate, meaning without a will. That category covers a substantial cut of the population. It's the same now as it was then. In such cases, intestate law, rather than the testator's wishes, will dictate how the estate is divided. The rules can vary with time and jurisdiction, and the court will have to appoint what we call an administrator. The feminine of that is administratrix, to handle the affairs of the deceased, since there's no executor who would have been appointed by the deceased in a will. There's no will, so there's no executor. Instead, we have a court-appointed administrator or administratrix. Note that a person who left a will, a person we call testate, can also have an administrator, but that's because he did not appoint an executor in his will. He just omitted that clause, or he may have appointed someone who had died since then, become incapacitated, moved away, refused a responsibility, proved to be irresponsible, and requires a replacement, etc. So here's a short way to remember that. The court always appoints an administrator. A testator, the deceased person making a will, always appoints an executor. Executors are always associated with wills. Administrators may be associated with either testate or intestate persons, but more often it's going to be the intestate, the people without wills. Estate records included both loose papers collected into files or bundles by the deceased person's name and labeled with the year of the earliest record in the file, or they can be recorded in books or ledgers containing copies of individual papers that have been turned into the court. These can exist together, or there may only be one or the other. And the bound volumes may carry different labels. For example, general minutes of whatever court was designated to handle estates, and that varies from state to state. Guardian accounts, records of administrators. It could be called wills, inventories, and accounts, records of sales, records of dowry, estate divisions, appointment of administrators, executors, and guardians, record of settlements, etc. And the names for these books is multivarious. My point is bringing in bringing all that up is that you should definitely check both for the existence of loose documents associated with estates and also for any documents that might have been copied into bound books like the ones that I've just listed for you. One type of record might survive while the other has not. I've seen entire estates where there are no loose papers existing, but there are copied documents in these ledgers. I have frequently found that estates involving wills often generate subsequent records documenting how the provisions of the will were carried out, or legal matters that were contested about the will. These were returned by the executor and survive as copies in bound ledgers, but may not have corresponding loose documents preserved in estate files per se, or they may. The minutes of the court that oversaw estates in particular places will also contain brief references to the various stages of estate settlement and provide a timeline from when various actions and documents were filed. So some loose or recorded documents will have corresponding notations and minutes of the court that oversaw estates for that area. Most estate papers relate to intestate people, but not all. When a will required long-term management of property by executors and guardians, when there were minors involved, when there was litigation over the terms of a will, when there were complex business affairs and significant debts that had to be handled, you're likely to find that there's both a will and an set of estate papers, either recorded or loose. Loose estate papers and books of recorded estate records may be kept in the office of the county court overseeing estates. Older records may have been forwarded to the state archives or duplicated by them from local records. It depends on the jurisdiction. Of course, in North Carolina, all the older records are usually at the archives in Raleigh. Many have been digitized in the will and probate records database on Ancestry we mentioned earlier, or in Family Search under the Search Records category, and then under their individual states. Again, some years and counties are included and others may not be, depending on the jurisdiction. Some are indexed by the name of the deceased. Some are indexed by every name appearing in a will and Ancestry, often not very accurately. With AI coming in online now and handwriting recognition technology, which is getting better and better, there's going to be more indexing. We've got a beta program already on Family Search that you can opt into, and it covers probate records for a lot of states. I'm not going to say that it's going to be entirely accurate. There are going to be a lot of bugs to be worked out on that, but eventually that's going to be a tremendous entree into the multifarious names that appear in these records. So keep an eye on developments there. Anything that gets access to more names is better, but with AI, you always have to be aware that there are going to be a lot of mistakes, and if a name is only mentioned once and it's boggled, it's not boggled, it's garbled or misread that one time, it's going to be hard to find. If a name is repeated a lot of times, at least once or twice, it's going to be correct as the AI recognition sees it. So that's something to keep on your radar as it progresses. It does often take a little work, even when the records are digitized online, to get at them. In cases where they're digitally inaccessible, people in the past have ordered microfilm, but that's more or less off the charts now. It's not really even necessary for most places. Even where records are restricted on Family Search at home, you can usually go to a local LDS Church Family Search Center or to Family Search affiliate library like our own and see the restricted records there if it's probate for most places, not all places. Now let's launch into the various categories and types of estate papers that you're likely to find. And for every one of them, I'm going to explain the purpose and the genealogical implications, including how they might affect enslaved people and the research of them. And I'll discuss these in the typical order that they are filed or generated during the estate process, taking an intestate estate as our focus because that's the predominant category of loose estate papers, intestate estates, where there's no will. First, we start off with administration bond. Soon after the death of the intestate person, an application for the right to administer on that estate must be filed. Beginning in the late 19th century, there was often an actual pre-printed form called an application for letters of administration. It will include the name of the person applying to become an administrator, the name of the deceased person, the fact that they had died intestate since the last term of court, usually within the last 3 months, the estimated value of the property, and the names of the heirs. Now, this slide gives an example of an 1878 Randolph County, North Carolina, application for letters of administration on the very minimal estate of Lydia Johnson. Her husband, by the way, was still alive, but because he was probably illiterate and incapable of handling that matter, H.T. Moffat is made the administrator here. He's the one who applies. He's declaring that his decedent, Lydia, died without a will recently, and she had about $25 worth of property to distribute among her children, and he lists them all here. Even though it's really scrunched up, they're all listed. You'll likely not find a record exactly like this prior to the Civil War, but earlier in time, you will frequently see just the administration bond, which is generally the next step. Now, this document acts as the administrator's official promise to the government to carry out all his duties thoroughly and in keeping with the law. Not only will he sign the bond, but also his security or securities will do that as well. Now, these securities or bondsmen are promising to help pay off the punitive value of the bond should he fail in his duties. He's not liable for that money unless he mishandles the estate. Nevertheless, the bondsmen are also taking a risk on his behalf, as any security or surety inevitably does, so they may be other relatives of the deceased or of the administrator. Now, the widow usually had first dibs on the rights of administration, and then it might proceed to other next of kin in this order: adult sons, sons-in-law, brothers, brothers-in-law, fathers, or uncles. Women could also serve in this role, but less frequently, and there's a strong presumption that an administratrix is usually a widow. When women serve who are not widows, it's usually indicating that there are no adult males in the family capable or available to do that. Now, sometimes the widow will renounce her right to someone else explicitly. Such a renunciation is usually a sign that the person in whom she places faith is either a relative or a business partner of herself or the deceased person. The value of the bond itself is often twice the estimated value of the estate. There are estates of small value where the administration bond is the only surviving document, but it's still useful, not just to identify a widow or next of kin, but to indicate the size of the estate and to give an indication of the time period in which the person must have died. When there are unlikely to be tombstones or death certificates, this is a big plus. Now, this document that you're looking at right here shows that the widow of Nicholas Holt Jr., Sarah, who was his second wife, felt incapable of taking on the burden of settling her husband's estate when he died about 1812 or 1813 in Orange County, North Carolina. In fact, her renunciation of the right of administration shows that she was illiterate. She signed by mark, more common among women of that era than among men, and thus probably couldn't have handled the situation herself very easily, although there are people who administer estates who are illiterate. And I think you can see her renunciation here. The previous image is the bond executed by the actual administrator that she requested. She nominated James Nicholson to take up those duties, and he accepted by making a bond that was secured by Joseph Clendenin. Sarah Holt's maiden name is unproven. She was the second wife of Nicholas Holt. We know for sure that James Nicholson was not related to Nicholas Holt. Could it be that James was Sarah's brother or brother-in-law, or maybe her nephew or nephew-in-law? That's a strong possibility. He could also have been merely Nicholas's trusted business partner. Though both James's family and his wife's family have been somewhat explored, there's no complete list of the children of James Nicholson's father or of his wife's father, and the search continues. But the situation illustrates how the naming of an administrator can be a clue to previously unknown family relationships. There are occasions when the court will appoint the largest creditor of the deceased as his administrator, and that's to guarantee that this person receives his fair due from the estate. Such situations indicate heavy indebtedness. One of the first concerns of a widow was to secure her rights before the creditors or the heirs took their cuts. And in general, her rights took priority over theirs. So when it came to the personal estate, she was to receive enough of the stock, the crop, and the provisions on hand, including furnishings and tools, necessary to sustain herself and her family for 1 year. Now this was done almost immediately because the personal property was the most vulnerable to sale. The proceeds from the sale would be used to pay debts and funeral expenses, and any remainder would be due to the heirs. So, in an estate plagued by debt, the right of the thirds was very important to the widow. The right to a year's support was also important. So she also had a lifetime right to 1/3 of the landed estate of her husband. So she would petition the court to have that portion of the land laid off to her. Now this is 1/3 by quality and value rather than 1/3 by acreage, and it would usually include the main structures on the property, including the dwelling or the mansion. That's not what we mean by mansion today. It's usually a very modest house, but it was the primary dwelling. Even though there may have been other buildings on the site, this was where the family lived. That's what's meant by mansion. It was hers to keep for life and to use for the income that it generated. She could even lease it to another person for her lifetime or sell her dower right. But she could not sell, she could not despoil it or alienate the land itself, absolutely or in fee simple. It was to go back to the heirs at her death, no matter who might have had those limited rights in her lifetime. So that often means a final settlement doesn't occur until the widow also dies. When you see the dower land being sold or sorted out by the heirs in a deed record, for example, or a later estate filing, it usually means that the widow has died, and that may be the only other indicator of her death that you have. The three kinds of documents involved in this stage of the record are the widow's applications to the court for thirds and dower, the court appointment of or warrant to the commissioners to perform these set-offs or surveys of land, and the commissioner report of what land was laid apart and set off, which are subsequently recorded. Now these records that you're looking at illustrate Nancy Reeves' application for her year's support and dower lands after her husband Frederick Reeves died in 1854 in Orange County, North Carolina, without a will or intestate. Her portion of the land is described in detail as it was laid off to her. In her application, she mentions specifically that her husband Fred died in the month of September 1854, which is a detail that we might find nowhere else. And she lists all of his children. Only one of them is also her child, my great-great-grandmother Jeanette Reeves, who is the last in the list. The implications of these documents include things like the applications for dower will often include a list of the heirs, because the widow is often suing the heirs, and we don't mean that formally, but just in a pro forma manner, in a formal legal manner, to get her dower or thirds. That does not mean that she and the heirs are at odds necessarily. The action is merely legal formality. In her petition, she will frequently mention that date her husband died, or simply state that he has died since the last term of court. A date of death where no tombstone, newspaper notice, etc. exists, potentially. If an application for dower, the document will usually describe his landed holdings entirely, sometimes in great detail, sometimes very summarily. The commissioners themselves are usually neighbors. They're well acquainted with the land, but they are not going to be relatives, either of the deceased or of the widow herself. And obviously such relationships would be an obstacle to performing their tasks fairly. That can be important, for you can see someone appointed a commissioner you thought might be a relative of either the deceased or the widow. When they were appointed, however, that shows that you are incorrect. They are not going to be connected by kinship. Not close kinship, but in any case. Once the widow's immediate needs have been satisfied, it becomes necessary for the administrator to account for all the assets and liabilities of the estate, and to find a way to satisfy all the debts and obligations made by the intestate person. That could be a very difficult process because many people today then keep their business affairs close to the chest, and records may be incomplete, disordered, difficult to locate. Usually administrators were interested in selling all the personal property they could get their hands on first, especially anything that was liable to spoil or be lost. Think, for example, of the livestock roaming free range in the woods, or crops in the barn or the field. Inventories were the first stage, and this is simply a list of all the movable assets of the estate and all the debts that may be due it. If estimated values are attached to the items in the inventory, we call it an appraisement. A set of appraisers may have been tapped to perform that service. When the stock of goods and their values have been accounted for, the property may be sold on one or more days, and an account would be made of what was purchased and for what amount, and that will be submitted to the court. That could be compared against the appraisement to keep a check on the fairness of the sale. Now, all sales would have to be advertised appropriately to attract enough buyers to ensure a fair price and revenue for the estate. Often the estate sales proceeded on a year's credit. So it wasn't all cash on the barrelhead. It would take time for the administrator to collect all the money. In the meantime, he might go about collecting debts due his intestate either by note or book account. Individual promissory notes are sometimes included. Some debts he would mark sperate, S-P-E-R-A-T-E, or that means collectible. He could collect those debts. And others he might mark desperate, D-E-S-P-E-R-A-T-E, or uncollectible. The persons owing are listed alongside what they owe, perhaps the date due, and any that are uncollectible may be given a reason, such as the person owing moved, or was deceased himself, or insolvent, etc. Of course, this was done to protect the administrator from liability for those uncollected debts. There's also a balance of everything collected and realized from the estate, and an attestation of authenticity and accuracy signed by the administrator. Lists of debts help you sometimes not just with the deceased, but with his neighbors who owed him money. Whenever you find two or more people owing a debt together, that may suggest that they are related to one another because they are backing each other up in their indebtedness, and that entails risk. Their condition may be described when the debt is desperate. Now, this slide is an inventory and appraisal of the enslaved people living on the estate of Charles Bright of Marlborough County, South Carolina, and he died in 1830. There are nearly 50 individuals. There's always the possibility that they've been ordered by family, so the order in which they are listed should not be overlooked. Clearly, some wives are listed next to husbands, after all. A man and a woman are sometimes listed just ahead of a sequence of boys and girls. The choice of ordering them that way may have some significance. The values also tell you something about the age, the physical condition, the skills of the enslaved people, as inhuman as that appears to us. This record shows a list of debts pertaining to the estate of Frederick Reeves, whom we mentioned earlier, with the amounts owed and by whom and the dates due. And you'll note two groups of debts, sperate debts, which are likely collectible, and desperate debts, likely uncollectible. Some of the debts are judgments. That is, they are amounts awarded by a court in a lawsuit. Poor Fred had a lot of bad debts due him. Some of the debtors are his relatives, which goes to show that it's not always wise to loan to your kin. And this slide shows a page from the estate sale of Michael Moser, what was now Alamance County in the 1820s. It was then in Orange County. It shows various items purchased at the sale with the amounts paid and who bought them. At least some of the buyers are usually relatives. On this page, the printed material in the family is being sold, and you can see that my ancestor Adam Moser, Michael's son, purchased a Bible for 7 shillings. A much greater value than any other book in the list, and most of them are less than a shilling in value. That put me in mind of a great large format Bible with a tooled leather cover printed in German in Augsburg in the 1760s, which my family inherited from this lineage. It has great straps and buckles on the text block edge to keep the covers closed when it's not in use. The family record was copied on 2 separate sheets that were kept in this Bible, all in handwritten German script. That suggests to me the origins of the Bible that my family still owns today, probably purchased by Adam Moser from Michael Moser's estate. So the genealogical implications of these categories of records, you'll have a sense of what the deceased owned and what kind of business and farm production he was involved in. The debtors and creditors may be relatives. The purchasers at a sale may be relatives. And even though they may not be relatives of the deceased, if you see multiple people from the same family coming to the same sale on a given day, maybe they're related to each other. That could be very helpful for poor people in the neighborhood who often had to go to estate sales to purchase secondhand items because they couldn't afford new ones. They document how family heirlooms pass down through estate sales sometimes. Note who got the Bible. See if you can trace down descendants of that individual and see if it still exists today. Get an indication, too, from these records of whether the deceased person was literate or not through what he owned: books, desks, inkwells, quires of paper. When it comes to researching enslaved people, you'll often find them listed near the beginning of inventories, maybe at the end, maybe at the beginning. They may have ages attached, but that's relatively rare. You may expect a designation: man, woman, old man, old woman, wench, boy, girl, infant are typical terms, or a value indicating age or special skills in an appraisement. Young children may be grouped with their mothers. Sometimes slaves are sold immediately with the other personal property, but it's usual, when no will directs that they should be sold, that they would be retained in the estate for ultimate division among the heirs, or sale and division of the proceeds at a later date. It's hard to say this, but it's nevertheless true. The enslaved were considered, from a financial point of view, much like accruing money in the bank. It was thought desirable to keep them for many years and to realize dividends through natural increase and the value of their labor. That is the heartless aspect of capitalism at work in the enslavement of human beings. But special application might be made to sell or exchange individual enslaved people for any number of reasons, principally to acquit debts and support the family, but also when enslaved individuals were considered ungovernable. These special applications and reports of sale might also be in the estate file. Now, any minor or incapacitated heir would require a guardian. The court would appoint someone to fill this role if the child was under 14. But at that point, he or she could suggest an adult or of his or her choice to become a guardian. Every guardian would bond, usually periodically, to maintain faithful stewardship over his ward's affairs, and annually would render an account of exactly what the heir's assets were and what the income and expenses had been for the year. Some of the loose accounts survive year by year, with credits on one side, debits on the other, a balance declared, and the guardian's attestation and signature. The series might end with a receipt from the ward to the guardian for the balanced year. Many guardian records do not exist as individual papers, but do survive as copies in bound books. Sometimes they're kept separately in their own category from the estate papers, so it pays to look for guardian's papers as well as estate papers. Administration accounts merely document the income and the expenditure of the entire estate rendered on a yearly basis until it was settled or finally divided. The genealogical implications are pretty clear. First of all, the guardian may be related to the deceased, and also his securities may be related, the securities on his bonds, to perform his guardianship faithfully. The accounts are an indication of the age or physical and mental status of the ward. When guardian records cease, you get a sense that the child has come of age, 18 for girls, 21 for boys, or marriage for girls, or that an incapacitated person has either recovered or died. The details of the accounts are simply fascinating at times. You may get a detailed idea of the lifestyle of the ward or the family as a whole. What books did they want to read? What kind of clothing did they have made for them? What amenities were allowed by the caretakers? Were the children in school, and where? Did anyone get sick during the year and require a doctor? Did family members travel? Because those travel expenses would be noted in the guardian's report potentially. If it involved expense, the guardian or administrator would account for it, though some caretakers go into more detail than others in describing the payments made. There's sometimes the makings of a biography in guardian accounts particularly. When slaves are mentioned in guardian and administrator accounts, it's usually on the income side, so you may find out which slaves were employed off the plantation or rented out. Their incomes and their employers are usually listed year to year, and that was done on a yearly contract. It might become apparent that some have special skills and fetch higher sums as a result. Looking into the employer's line of business, the person who hired them out for a year, could be fruitful. What if the employer was a blacksmith or a cabinet maker? Maybe that was the skill that the enslaved person was learning or already had. Articles of clothing purchased for slaves, for example, tools and equipment, doctor's services, or coffins for the deceased, indicating a particular enslaved person has died. A midwife for a particular slave, indicating that a child has been born. Perhaps an amount paid for the recovery of an escaped slave, or compensation received from the state for an executed slave, which would immediately alert you to look for a capital court case and get the details. This slide shows the guardian bond that William Coble executed for 2 younger children of my ancestor, George Welker of Guilford County in 1857. They were his children by his second wife, Molly Staley. Later, the widow and children moved to Indiana. And in the second petition on this slide, you have a new person, Joel Matthews, asking for Morgan County, Indiana, to have their guardianship transferred to him in 1859. The old guardian, William Coble, would have to turn over their assets, along with a full report of his administration. This application documents that the family moved between 1857 and 1859, which is important information. This slide includes an executor's account from 1811 and 1812 for the orphan sons of Levi Quick Sr. of Marlborough County, South Carolina. Among other things, here we learned that a stud fee was paid that year, a saddle was purchased for one son, and that another son was contemplating joining the army during the War of 1812, but then hired a substitute for $17. Also on this slide is an administrator's account for the estate of Charles Bright of the same county in 1832. Among other details, we learned that the family was erecting a sawmill in February and March of that year, and that they were rewarding their workers on that project, in part by purchasing whiskey for them to consume. Also of interest here are the specialties and occupations of some neighbors. Honor Pate, for example, was paid. She was the wife of neighbor Stephen Pate, and was apparently a midwife brought in to assist with a birth on the plantation. Thomas Quick provided a blacksmith service, and may also have been a tanner since he sold saddlebags to the Brights. The overseer is revealed to be someone named Parham, and that's all very wonderful information about the Bright plantation that we would not find any other way. Often the heirs would hold their property in common for many years, perhaps until the youngest child came of age, perhaps until the widow died, perhaps until several children decided to move away, or perhaps because unmarried children were still living on the property. It might be their deaths that sparked the division. And by the way, the estates of intestate unmarried uncles and aunts are the very best of all, because all the nieces and nephews, sometimes for several generations, have to be accounted for and receive a portion. Sometimes several heirs and their families were actually still living on the ancestors' land and sharing its resources in common, but at some point this arrangement would become untenable and a division would become imperative. An application to the court would be made and an order would be given. Usually this action takes the form of some heirs suing others, but it's not really usually a hostile action, an adversarial action. It's entirely pro forma or ex parte, without opposition. There may be some heirs, always, among the defendants in the ex parte action who are no longer living in the area. The court would require that they be given notice of the sale or division by publication in a local newspaper. Other heirs might renounce their claims or sell them to another heir or an outsider, which should be a caution to you that you're not to necessarily assume that every person who receives a portion is an actual relative. Some of those people may have purchased their rights from another actual heir. Now, those documents of transfer are also sometimes in the file, and still other heirs might have their portions in the estate attached by the court to pay a debt or a judgment that they owed. Evidence of that might be in the file. Again, if that heir was not still in the community, which is frequently the case for a person deeply in debt, they may have fled their creditors, newspaper notice would have to be made as well for them. Finally, you sometimes see a case in which each heir's share must deduct items advanced her by the deceased in that person's lifetime. These advancements may be declared among the papers so that an equal division can take them into account. Divisions usually relate to enslaved people held in common or land held in common. When the order is issued, commissioners would be appointed to divide the property into lots, one for each heir. Each lot would be assessed a value, and the beneficiaries of more valuable lots, these lots were assigned usually by chance, would have to pay the recipients of less valuable lots their differences. Commissioners again would be unaffiliated by blood or marriage. We call blood relations in these documents often relationship by consanguinity or by common bloodline, and those by marriage we would call affinity, relationships by affinity. A person would have to be unrelated in either of those respects so that they could act impartially in the division. That's why relatives are not going to be chosen as commissioners for division. Another way to effect a division is to sell the property all at once and divide the proceeds. This course was taken when land was insignificant in quantity or too infertile to be divided profitably. So the genealogical implications of these types of records are that you get a list of heirs, obviously, that you might get a plat of the land and exactly how it was divided. You might ask yourself what change in family life sparked the division. For instance, it might have been precipitated by the widow's death or by the youngest child finally coming of age. Migration of heirs can be indicated as well, and that's another benefit of the records. So for slave divisions, obviously the record of sale is extremely useful in tracking individual bondsmen and women. Slaves were sometimes bought as family groups. Certainly young children would be grouped with their mothers. Value may indicate something about the ages, health, or skills of the enslaved. Certainly income potential and fertility were key to value. Enslaved people considered rebellious might fetch lower prices as well. So this slide shows the report of an enslaved division among the two children of William Lightfoot Hayes of Chatham County, North Carolina in 1839. Note the mention in Lawrence and Anne Huff's portion of a slave named Stanford, who is called a cripple. For this share, an amount was deducted from the total value of their portion to compensate for the physical condition of Stanford and in order to keep the shares even. But here you find out something about an enslaved person that you might not otherwise have known. One can only imagine the misery that might befall a disabled slave, viewed more as a burden by the owners than an asset. This slide includes plats in a commissioner's report dividing the lands of Robert Peel of Richmond County, North Carolina, some 40 years or more after he had died in the 1860s. The delay in the division occurred because the widow Mary Peel only died in the 1890s. There are 2 tracts, and each is platted with the divisions allotted to each heir. All the structures on the land are located on the map. Each section is also described according to its metes and bounds. In one of these descriptions, we learned that there was a Negro graveyard near the corner of division number 13 of the home tract, which could be exceedingly interesting for somebody descended from the former slaves of this family. It's also near the South Carolina-North Carolina boundary. Robert Peel owned a handful of enslaved people in the 1860s, less than 10, so could this be where some of them are buried? Could this site be located today? Well, obviously it could, based on this record alone. And then we have all the records in the estate file related to some kind of court case regarding the estate, papers related to litigation. Often it might be administrators that were forced to sue debtors for sums owed the deceased. Sometimes they themselves were sued, that is the administrators, by people who alleged that the deceased person owed them money or had made an unfulfilled agreement with them. Sometimes the litigation was over property which the deceased person held in common with another individual, like a business partner or sibling, or it was necessary to determine where his own rights began and ended in certain property that was held in common. Sometimes the heirs or widows sued the administrator or executor for mismanagement of the estate. Sometimes the heirs sued each other over what was rightfully due them. A common example is when one heir claims that he deserves a larger portion for services rendered the deceased, for instance, caring for him or her in their final sickness or old age. All the papers associated with such cases might be in the estate file, including complaints or petitions of plaintiffs, answers from the defendants, summons, witness tickets, affidavits, attorney notes, summary testimony, promissory notes, written contracts, other evidence of obligations. Such cases might also exist apart from the estate file, so that it makes sense to check the local court records around the time a person died to discover any and all litigation that might have arisen because of his death. Obviously, a big part of this is entitlement to slaves, and when these suits at law became especially elaborate, they can provide several generations of information about descent from a particular enslaved person. Obviously, all the increase of a slave was due the heirs who got the court to recognize their title to the original slave herself. Sometimes she was already deceased when the case was brought or resolved, and this may be noted. Now, I said she for a reason, because increase and ownership follows the female, not the male line. Female slaves with childbearing potential were hotly contested among heirs for this reason. Now, the slide that you're looking at gives some bills, receipts, and declarations of debts that make up most of the estate records of George Welker Sr., who died around 1802 in Guilford County. They may not look like much, but careful study reveals some very important details. We get a signature of the deceased in German script on a note that he signed, for example. We get a good sense of his date of death from a receipt documenting payment for the funeral sermon. Also, we get the name of the parson who gave the sermon. His fondness for fine hats is clear from a couple of these, as well as the fact that he was probably paying for schooling and boarding of his youngest son Jacob with Solomon Porch about the time that he died. We also see a lot of liquor and brandy being bought after his death, and this was probably used at the sale of his goods and at the wake. Of course, most social occasions at that time involved alcohol. With a sale, it was probably thought that money would flow more freely if the purchasers were, shall we say, a little more relaxed. Now what you see here is a illustration of all the information about enslaved people gathered from a lawsuit involving the heirs of Nicholas Holt Sr. of Orange County, now Alamance County, who died about 1787. He mentions the 4 slaves in the will, and these are underlined in the chart, and gives them to his 4 sons, with the woman Dinah being allowed his wife Eve for her lifetime. Then she and her increase, that is Dinah, were to go to the sons. So the question in this lawsuit, some 40 years after the death of Nicholas Holt Sr., was how in fact had the sons agreed to divide these enslaved people? Had they ever come to a clear agreement on Dinah and her increase, that is her children and grandchildren? Some folks said one thing, other witnesses told a different story, and that was the crux of this suit. Witnesses were brought in, and depositions were made about Dinah and her family, even from folks who had already gone to Tennessee. From these we can glean all the information I put into the chart, including the fact that Simon was Dinah's brother, and that he was born in 1775 or thereabouts, the relationships to Dinah's children and grandchildren, the fact that her son Jesse had been taken to Tennessee by John Holt, and which slaves belonged to whom over time as the family sold them or lost them due to their unpaid debts. I have suggested in the chart that the oldest slaves mentioned, John and Phyllis, were probably the parents of Simon and Dinah, given that they were the only 4 slaves that Nicholas Holt ever owned. We know Simon and Dinah to be siblings from the written testimony, however. So at some point, the administrator would seek to wind up his business. All the property had been sold or divided. The widow had been given her due. The creditors had been satisfied, but there might still be a small balance in the hands of the administrator. At this point, he might submit his final account or his settlement, listing the remaining assets and how they were dispersed to the heirs per stirpes, that's Latin for by branch, or according to their rateable shares. That list may be given with the amount each heir received. I have occasionally seen per stirpes lists in a final account in which the amount is given and each heir is named, but nothing specific is mentioned about the relationship to the deceased person. The share as a proportion of the whole may help you figure out the relationship alongside other records. Individual heirs might sign receipts for their final portions and renounce any future claim on the estate. If all the business of the estate was not quite finished, heirs who got their portions early might have to sign refunding bonds. That is, they agreed to pay back their proportional part of any new obligation or debt that might arise or be upheld against the estate. Clearly, the identification of the heirs and the indication of their relationship to the deceased is the key element of these records. The receipts also sometimes reveal migration of some of the heirs to other localities. Here we see from the estate of Nicholas Holt Jr. of Orange County various records created after his land had been sold. Some of it he held in common with Obed Green, you will see. By the way, pertinent to something I mentioned earlier, James Nicholson, who administered this estate at the request of the widow, was married to a Green, likely a relative of Obed's. Again, an intriguing clue. But the point here is that a full list of the heirs has been assembled. Some of the children of Nicholas Jr. are already deceased, which is duly noted in the list, along with places to which these children migrated. So the grandchildren were to get that share instead divided equally among them. On the second page, some of those are listed with the shares in the land sale next to their names. A full child share was $33.25, and that goes to the surviving son Solomon Holt. And so we can divide 33.25 and kind of get some of these other numbers that are smaller. And here we see the final division of Nicholas Amick's estate in 1804 in Randolph County, with the amount given to each. A sum is held in reserve for 3 heirs that are listed at the bottom, who were apparently not at hand to be paid. Perhaps they had migrated elsewhere. The first entry is Cash Paid Wilker, Wilker, which suggested to me, when I finally picked up on it, that the first wife of George Welker Sr. must have been the daughter of Nicholas Amick, long dead by this time. As we've seen, Welker himself died only a couple of years previously, and in fact, one of Nicholas Amick's daughters, baptized in Pennsylvania before the family came to the Carolinas, was old enough to be the mother to Welker's older children, and had a name repeated in the Welker family, so I take her to be the likely first wife of George Welker Sr. So what do you do if there's no probate record to be found for an individual that you know died? Well, first understand that many people died without enough property or business concerns to require an administrator or to write a will. This is particularly true of certain populations, poor and landless people particularly, and women. Researching people in these categories is quite a different topic for another day. But you will see readily from our discussion that there's a potential to learn details about a person and his relationships is lost when no probate process occurs. There are occasions, however, when you know someone had significant property and yet still seems to have left no probate records. So how can that happen? What can you do about it? Well, perhaps the person died in a place you didn't expect. Check different locations. Perhaps the county records have been fully or partially lost in the area where your ancestor lived. Check for gaps and look at what remains carefully for the years when you suspect the death occurred, privately on the state level, locally, and in adjacent counties. Perhaps your ancestor made arrangements to divide property prior to death. Such arrangements are usually recorded in the deed books. Perhaps your ancestor's property was taken because of litigation against him prior to his death. Court records could help there. Perhaps your ancestors settled the estate privately if the person died intestate. This is very common in the colonial era because primogeniture was a very clear rule dictating that all the land, and in Virginia all the slaves as well after 1705, were supposed to go to the eldest surviving son. The younger children got a cut of the personal estate, but it could be such a minor affair that there was no need to register those documents. In such cases, the deeds and tax lists may be the only records to reflect who occupied the land next in succession, and you can bet that it was the eldest son. But there can be situations even after colonial times when the other heirs may have sold out to one in particular and the deeds for this were never recorded. That is the idea behind the statement, follow the land, which is the subject of another talk given on this YouTube channel. Probate records are clearly some of the most important that genealogists have at their disposal. They're usually arranged logically with at least testator or decedent indexes, sometimes with cross indexes to heirs. They are increasingly easy to access with all the digitization that has occurred. To reiterate, one of the first things you ought to do when you run up against a relationship barrier in your research is systematically investigate and take notes on each will and estate record for that family name in the locality where you're conducting your research. Probate records can also help you with neighbors and friends of the deceased, and they're particularly useful for poor and landless families. By studying the probate records of an entire neighborhood, particularly merchants, artisans, professionals, craftsmen with wide-ranging business affairs, you may discover clues about relationships in those nearby families. For instance, Did some of your poor relatives attend a neighbor's personal property sale on the same day and leave their names on the list of buyers? Could that be an indication that they accompanied one another to the sale and are related to one another? Did they lease land from an estate? Did they owe money, singly or in pairs, to a neighbor? Do their promissory notes survive in the neighbor's estate? Who witnessed those, and who were the guarantors? Did they sue the estates of wealthier neighbors to defend contract obligations or collect sums owed for work performed? Again, these could be clues concerning the neighbor's family, not the deceased person's. Lots of clues may be revealed when you study entire communities and not just individual surnames.